The performance of contracts, section 37. First is the obligation of parties to perform contract. In that, first is who must perform the promise. A party is released from performing his part of the contract by law. For example, an insolvent from paying his debtors. A person's promise are binding on his representatives in case of his death unless a contrary intention appears from the contract. Means according to that contract, the person is liable to do that contract, and in the case of the death, his representatives are responsible to perform that act. Second is the who can perform the contracts. The parties themselves are under obligation to perform their duties and promise. The promisors, the agent, the legal representatives, the third person, and the joint promisors. So all these people, depending upon certain circumstances, are depending upon the obligations performed in the contract. Third is the time, place, manner of performance. These are fixed on the desire by the convenience of the parties of the contract. They are decided by the wish and the will of the parties. When the time is fixed for a contract, then the wish must be fulfilled within the reasonable time given only. Means when specified period or a time is fixed or given in that contract, then the parties are liable to perform that act within that time period. And last is the time. So time is another important factor for the contract. The parties must perform their promise within the given specific time only. Time depends on the nature of the contract, subject matter of the contract, object matter of the contract, and the term decided within the parties. So these are all the obligation of the parties to perform a contract. First is that who must perform the promise. Second is who can perform the contracts. Then the time, place, manner of the performance, and time.